Before we dive into this courtroom showdown, buckle up, because this case is absolutely stacked. We've got a defendant juggling felonies across multiple states, a judge who's had enough, and a list of charges so long it practically needs its own zip code. What you're about to see is a rare moment where a judge connects the dots across jurisdictions and confronts a defendant who's been playing legal hopscotch for years. Stay with me, because this one spirals fast and the outcome will shock you.
She has an open aggravated robbery of over 65 or disabled. So do I venture a guess that that is allegedly probably taking care of an elderly?
Right from the start, the judge wastes zero time drawing attention to the seriousness of this record. When a judge begins with aggravated robbery, credit card abuse, and felony theft, you know the courtroom is shifting into high gear. What's wild here is not just the number of charges, but the pattern: repeated offenses across different states, all involving vulnerable victims or financial exploitation. This is exactly the kind of history that makes judges skeptical of release. Before the defendant even speaks, the judge is already telling the audience and the court that this isn't a one-off mistake. It's a lifestyle of criminal repetition. Let me know in the comments, is this someone you think deserves bond?
Really? Wow, you have been a very busy person. Let's go through your stuff. So at the outset, it looks like you're wanted out of state for one reason or other. I have no idea. I know you're going to tell me it's all gumdrops, tulips, and little bunnies jumping, right? But how I get to know you is how you look on paper, right? What I see now, you have a credit card abuse that's open, a felony credit card abuse, a felony theft, 2,500, 2 or more times open, a felony fraud, another credit card abuse open, another credit card abuse open, another felony theft open, an aggravated robbery. Is that it? And then what else you got open out of state?
She has 2 thefts of properties from Houston County, Alabama.
No kidding.
Yes.
What would you like? A unicorn.
Chet, I understand and I see it, but she's got a lot of skin in the game. She's got about...
Here's where things get complicated and emotional. The defense pivots hard, pointing to tragedy and personal hardship: a sister shot in the face, a funeral missed, family devastation. These aren't small events, and they absolutely impact a person's mindset. But the judge isn't evaluating grief, she's evaluating risk and history. Defense attorneys often use emotional context to humanize their clients, and it's effective. But when stacked against a documented pattern of crime, judges tend to focus on protection over sympathy. What do you think? Should personal tragedy influence release decisions, or should the record speak louder?
About, I don't even know how many thousands of dollars of bonds on felonies that she's made. And technically Alabama's just minor thefts. Realistically, we don't want Alabama to spend the money to come get her. She's going to put up her own money. And you know what? She's going to have not only this bond, she's going to have all those other bonds up in the air. And so she's got a lot on the line, and we discussed that. Now, the failure to appear, Judge, I know just one more argument, was only because she was in jail here. She was keeping up with the Alabama case. Does not bode well the number of cases and types of charges, of course not. But she technically, it was not really a failure to appear, it's just she couldn't go. She has been keeping up with it. Her family is very invested in helping her and got a lot of financial investment. And as a side note, I mean, she's been feeling it. Her sister got shot in the face, 20-year-old sister shot in the face, and she had her funeral yesterday and she missed it. So
that sucks.
She understands like what's been going on, and she's feeling it.
And sister died.
My little sister.
That sucks.
Her boyfriend shot her in the face with some news. So she's very, you know,
It's awful.
I'm not speaking for you, but is this something where you are committed? And she understands if she doesn't go within 14 days, it's not just this bond, it's everything.
She has an open aggravated robbery of over 65 or disabled. So do I venture a guess that that is allegedly probably taking care of an elderly and she takes a bunch of credit cards and uses them? Is that?
I would have to see if they're the same offense. But Judge, she's also had similar history in other states within the last few years as well. So we wouldn't feel comfortable releasing her on bond. We have concerns that she would be a danger to the community if we did so.
I think so too, Ms. Smallwood. You've repeatedly shown to us that you don't care about our public.
This is the turning point, and honestly, you can feel it. When a judge starts listing out 7 open cases, plus out-of-state charges, plus similar offenses in another state, that's game over. Judges look for one core thing when considering bond: can I trust this person to stay out of trouble? And here, the history paints a clear picture. Every time she's released, she picks up a new case within months. The judge isn't just denying bond out of frustration, she's making a preventative decision. She's protecting the public, and believe it or not, she's also protecting the defendant from continuing a cycle that only gets worse.
Our public. You don't care about our bond conditions. And that is evidenced by your 1, 2, 3, 4, 5, 6, 7 open cases here where you have been filed on in multiple dates. And you also have multiple offenses in Alabama, and then you have similar offenses in another state. So essentially, you are playing hopscotch with the states with criminality. And you want me to give you a bond? Really? I would like hair, but I'm not going to get it. That's just a sad fact of life. Like here, it's also a sad fact of life. I'm not giving you a bond, because if I let you out, what's going to happen? Historically speaking, every 2 months you pick up a case. So if I let you out in 2 months, you're going to pick up another case. I don't want that to happen. Sometimes we have to protect people from their own selves. You are your own worst enemy. And now I'm going to protect you from yourself. I'm not giving you a bond. I can't trade it.
Understood. Thank
You know what I mean? And not only that, all the money she's posted here, 1, 2, 3, 4, 5, 6, $60,000 bond. Whose money is that?
This part is fascinating because it reveals another layer. Where did all the bond money come from? The judge notices that every case is tied to credit card abuse, and that raises red flags. When defendants post tens of thousands in bonds while being charged with financial crimes, judges start questioning the source of those funds. Not accusing, just connecting the dots. Judges see patterns every day, and when those patterns repeat across states, across victims, and across time, leniency disappears. This is the moment the judge essentially says, no more chances.
All these are credit card abuse cases. She's getting money from somewhere, some other place. No. Sorry, man. You're staying with me. Just let Alabama know that I'm not, so that they can come get her. The good news is that you've made bond on these cases. So we now give Alabama 14 days to come get you. If they don't come get you, then they'll file a dismissal. Or has she waived?
She has waived. What date did she waive?
September 25th.
Yeah, so you have actually 13 days. No way, Ms. Smallwood. It's time to pay the piper. Thank you. You were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On September 19, 2024, an officer was dispatched to assist a firefighter call at 100 block of Delano Street in Harris County, Texas. The wheel witness, the firefighter Paul Dean, stated that the defendant was asleep behind the wheel at the stop sign. of the 100 block of Delano Street. The will witness tried waking the defendant up and tried to pull him off from the scene, and then came to a stop when other firefighters blocked his path. The officer observed a mild odor of alcohol, glassy bloodshot eyes, and swing. The defendant stated that he was coming from an Airbnb downtown and had nothing to drink all day. Standard field sobriety tests were conducted, and the officers observed 6 out of 6 signs for the horizontal gaze nystagmus test, 6 out of 8 clues for walk and turn, and 3 out of 4 for one leg stand. The defendant declined to provide a sample of his breath, and a blood search warrant was executed.
Are DWIs?
Yes, sir. So it looks like we had, it looks like there was a DWI/open container that's currently pending in Fort Bend, and another one from this year
What?
pending in.
Kidding. This is
Switching
his
cases
third.
now, and this one is equally intense, but for different reasons. Multiple open DWIs is one of the biggest red flags in bond hearings. Why? Because it directly threatens public safety. The judge's shock is real, not performative. When she says, "Holy moly," she's reacting as both a judge and as someone who sees what drunk driving does to families. When someone already has 2 DWIs pending and gets another one, judges lose all trust instantly. And the bond jump from PR to $50,000 shows exactly how seriously repeat DWIs are treated. Think about it, should someone with 3 DWIs be allowed back on the road? Comment your thoughts.
Kidding. This is his third open DWI?
Yes, and then it looks like the second one is in Oasis.
You really have 2 other open DWIs? Holy moly, mother. Oh. And you got a PR bond in this case? Guess what I'm doing to that PR bond? Guess how high I'm making your bond now, Mr. Gonzalez? Yeah, probably $50,000, dude. You have 2 other open DWIs. You've not picked up another DWI? I'm revoking your bond, and I'm now setting it at $50,000. And I'm going to tell you now, if you get out of custody, you will have such strict conditions that if you violate this thing, I'm going to light you up like a freaking Christmas tree. You were not allowed to drive whatsoever. You will be signing an affidavit with me today, Mr. Gonzalez. If I find that you drive, I will have a contempt hearing, and every time you drive, I can put you in jail up to 6 months, and I can stack it. Do you understand? He really has 2 open other DWIs. God. Home confinement if he gets out. GPS monitor prior to release. Can you file interlock paperwork, please? You're not allowed to drive any vehicle whatsoever. And did he have an interlock on this car now? Because he's probably ordered to have one. So he has 2 open DWIs in 2 other counties now.
Who's this defendant, Judge?
Gonzalez. They gave him a PR bond in this case. Ixnay on the PR bond A. And I'm actually going to make it extremely high as well, because that's, Mr. Gonzalez, if you have a drug and alcohol problem, you better address it, because if you don't, I'm going to do it for you. Baloney.
No, I've been looking for programs.
I believe you. Sometimes you start looking a little bit too late and you do catastrophic damage. I'm now going to intervene so that that doesn't happen. All right,
what
I'm going to
we've
have
seen
you come
in
up.
this hearing is a textbook example of how judges balance compassion, public safety, and a defendant's track record. In the first case, years of repeated financial crimes across states led to a full denial of bond. In the second, multiple open DWIs triggered a massive bond increase and strict driving conditions. These aren't just courtroom moments, they're reminders that patterns matter, consequences build, and judges step in when risk becomes undeniable.